So, how is it that associations have legal standing to sue? Well, first, what is legal standing? Sometimes known by the Latin term locus standi, it is the right of a person or an entity to file a lawsuit or to participate in a legal proceeding in state or federal court. It's essentially a legal threshold that must be met before a court can consider the merits of the lawsuit that's been filed. Now, as a general rule, in the federal court system, there is a requirement that a case or controversy exists. This is due to the provisions setting that forth in Article 3 of the United States Constitution. On the other hand, in California, no such requirement exists. The California Constitution, in Article 6, dealing with the judiciary, doesn't contain the same case or controversy requirement. And courts do not consider public interest standing to violate California Constitution separation of powers, which is a doctrine contained in Article 3, Section 3 of the state Constitution. Nonetheless, similar to the federal case or controversy requirement, California standing serves to ensure that the courts will decide only actual controversies between parties with a sufficient interest in the subject matter of the dispute to press their case with vigor, as the courts have said. So, what's the standing requirement for an association to sue in state court? Well, the California Supreme Court has decided this matter, and it instructs us how an organization has standing to enforce or to challenge a state action. An association, whether it's a business, trade group, a union, or other entity, is allowed to sue on behalf of its members, even though the association itself may not have actually suffered any harm from the challenged state action. Our state's high court, our Supreme Court, has explained that an association will have standing to file a lawsuit on behalf of its members if three tests are met. The first test or requirement is that at least one member of the association could have met the private interest standard if that member had sued individually. This test is usually met when an association member files a sworn declaration explaining that the challenged action would harm them. Second, the association must demonstrate that it's attempting to protect the interests of the association's stated purpose or purposes of their existence. In other words, are the association's interests in filing that lawsuit germane or related to the purpose for which that association exists? And third, there must be a showing that neither the claim asserted in the lawsuit nor the relief that's being requested by the association would require the association's individual members to participate in the lawsuit being filed. So this three-part test is for associational standing, and it's similar to the test under federal law for an association. And then assuming that these three requirements are in fact met, then the association has standing to sue on behalf of its members in either state or federal courts as a general matter.